Hi, I'm Gina Johnston.
And I'm Thomas McFarlane.
In this video, we are going to look at settling disputes.
As mentioned in an earlier video in this series in relation to the progress of a court action, only a very small percentage of disputes ultimately end up in Scotland's courts and tribunals. The vast majority of cases are resolved before reaching that stage, and of those cases which do end up in a court, the vast majority of those are normally resolved prior to a substantive hearing or judicial determination. In most cases, the parties will negotiate a settlement in order to bring the dispute to an end as quickly as possible, and this is normally due to the time, uncertainty and costs involved in the litigation process. Typically, negotiations are between solicitors for the parties by way of written correspondence, but parties can also negotiate directly or with assistance from a mediator, for example. In most cases, any discussions will be without prejudice, and that is to say that the parties will agree that nothing discussed during any of the meetings or in the correspondence with a view to settlement will be used in court should the case ultimately proceed to that stage. So what if a defender wants to make an offer which they can later rely on in court? In Scotland, we don't have Part 36 offers that are encountered in England and Wales. Founding letters can of course be referred to in arguments in relation to expenses at the end of the litigation, but in Scotland, a formal settlement offer by a defender is made by way of a minute of tender. Minutes of tender are regulated by case law precedents rather than formal procedural rules. Now, a tender is an explicit, unqualified and unconditional offer made by a defender in an action to pay a specific sum in settlement of the case, and that's inclusive of interest as well as the pursuer's judicial expenses up to the date of the tender.
An important point to bear in mind about tenders is that unlike in England and Wales, it is not possible to make an all-in tender to pay a certain sum which is inclusive of expenses. So if I were to offer a tender for say £100,000 inclusive of interest and expenses, that would not be considered as a competent tender in Scotland. In order to be competent, the tender has to be for a principal sum plus an agreement to pay the pursuer's judicial expenses in addition up to the date of the tender. For more information in relation to judicial expenses and how those are calculated, please see our separate video in this series in relation to recovery of expenses.
If the court's award in the case is higher than the tender, then expenses are awarded as normal to the pursuer, so the tender has no effect. If the court's award is lower than the tender, then expenses are only awarded as normal until the date of the tender, after which the pursuer cannot recover their expenses, and not only that, they must pay the defender's expenses during that period. So there is, in effect, a double whammy for the pursuer who fails to beat the tender. The rationale here is that the pursuer should have accepted the tender as a reasonable settlement and therefore bears the expenses burden for the continuation of the action. Unlike in England and Wales, there is no 21-day period for the acceptance of a tender, and a tender can be withdrawn at any time. Now, the date of the tender in Scotland is not the date it was issued, but the date on which it ought reasonably to have been accepted, with a pursuer allowed a reasonable period of time to consider a tender. There is little case law guidance on how long a reasonable period is, but courts have said that the later the tender is made in an action, the more time that will likely be allowed for its consideration. Nonetheless, it is still important to consider a tender as quickly as possible. Now, although a minute of tender is lodged in the court process, it's important to note that it's not available to the judge and they will not consider it when deciding the outcome of the case.
In Scotland, it is also possible for the pursuer to make a formal settlement offer, which is known as a pursuer's offer. This is where the pursuer offers to accept a certain sum in full and final settlement of their claim against the defender, with their judicial expenses to the date of the offer in addition. These can be utilised to put pressure on a defender to settle a case, particularly given the additional rules regarding interest and expenses depending on what transpires after a pursuer's offer is made. Where the court is satisfied that the pursuer's offer was accepted late, the defender is found liable for interest on the principal sum from the date of the offer and also for payment of an additional sum of expenses to the pursuer. That additional payment is a 50% uplift on the pursuer's expenses for the period from when the offer could reasonably have been accepted until it was accepted. The rules also provide for the defender to be found liable for payment of the same additional 50% uplift in expenses to the pursuer where an offer is not accepted and where any court award is the same or better than the level of the pursuer's offer. We hope you found this video on settling disputes of interest. If you have a dispute on which you require legal advice, then please do get in touch.